Hello everyone. In the first set of presentations titled The Introduction to Laws, which consisted of 16 presentations, an attempt was made to give an idea of the concept of law and the scope and importance of various branches of law which are important in our day-to-day life. This second set of presentations focuses on the general principles of criminal law. The first of them would be on the concept of crime. We all must agree that the branch of law that touches and concerns man in his day-to-day affairs is criminal law, that is, the law which deals with crimes. We already know that law consists of rules of human conduct or behavior, and these rules are enforced by a political authority, that is the state. In a wider sense, the rules of conduct also include moral, social, and religious rules which are aimed at maintaining order and avoiding chaos, thereby ensuring peaceful coexistence among human beings. Violation of such a rule of human conduct would be a wrong which is likely to reduce human happiness. Lying, gambling, etc. are some examples of such wrongs. Wrongs may be moral wrongs, private or civil wrongs, or public wrongs or crimes. Moral wrongs are wrongs which are not considered serious enough, and hence the law will not take notice of them. However, such conduct is disapproved and hence taken care of by the social and religious institutions. Examples of such moral wrongs are ingratitude, indifference towards others' suffering, etc. Civil wrongs, also called as torts, are serious enough for the law to take note of, but the injury here is suffered by only an individual or individuals rather than by the society at large, and hence the injured has to approach the court for redress. Here, the person who committed the wrongful act has to provide compensation to the injured party. Example of torts include deceit, negligence, libel, etc. Public wrongs or crimes, on the other hand, are serious enough as they are directed towards the public at large and tend to affect the peace and well-being of the society. In such cases, though an individual or individuals are affected by the wrongful act, as it affects the society at large, the state initiates action against the wrongdoer and punishes him for the wrongful act. Now, what is a crime? We attempt to define crime because it helps us in identifying what kind of an act or omission amounts to a crime. But as the notion of crime changes with time and place, it is difficult to define crime correctly and precisely. Nevertheless, attempts have been made to define crime by laying emphasis on various aspects of crime. Blackstone defines crime in terms of violation of public law. He says that crimes are acts committed or omitted in violation of public law, forbidding or commanding it. Here, we have to define public law. If public law is interpreted as including only political offences, it is narrow, and if interpreted as including violations of municipal law, it would be very wide. He later modified it as violation of public rights and duties due to the whole community considered as a community. Crimes include not only violation of public rights and duties, but also violation of certain private rights and duties like libel, trespass, etc. Sometimes there may be no violation of any right or duty, but still it may amount to a crime. For example, possessing counterfeit coins, etc. Sometimes a person's conduct may amount to a crime even though it is not injurious but advantageous to others. Hence, these definitions are criticized as narrow in scope and general in nature. Crime has also been defined in terms of morality by some jurists. Garofalo defines crime as immoral and harmful acts which affect the basic sentiments of piety and probity, that is, righteousness or rightful thinking of the society. Though some crimes are immoral and harmful, like murder, robbery, rape, dacoity, etc., All immoral acts are not crimes. Example, ingratitude, lack of sympathy towards other sufferings are no doubt immoral but are not crimes. Similarly, all crimes are not immoral acts. Traffic offences, offences relating to essential commodities, tax and custom violations are not truly immoral but are still offences. Thus, all immoral acts are not crimes and all crimes are not immoral acts, and hence this definition is not considered accurate. John Gillens gives a sociological definition to crime. According to him, crime is an act which is believed to be harmful to the society by a group of people who have the power to enforce their beliefs by banning such acts and imposing penalties for violation of the ban. Here, a society at one time may consider an act harmful and hence declare it a crime, and subsequently decide that it ceased to be so and hence remove it from the list of crimes. Similarly, an act which was not considered a crime at one point of time may subsequently be prohibited under penalty. For example, adultery was a crime but ceased to be so in England now. Similarly, in India, dowry was not an offence till 1961 but became an offence after 1961. Here, the nature of act does not change and the change is only that of legal classification, and thus this definition does not help in identifying a crime. Some writers defined crime in terms of the nature of proceedings adopted. According to Austin, a wrong pursued by sovereign or his subordinates is a crime, and according to Kenny, a wrong whose sanction is punitive and which can be remitted only by the state alone and not by the individual is a crime. These again are narrow definitions and are inaccurate because in case of certain offences like bigamy etc., the individual wronged is required to initiate the criminal proceedings or prosecution, and in case of certain offences like hurt, assault etc., the complainant has the power to compound the offence, that is, remission is possible by private individuals also. Edwin Sutherland defines crime in terms of criminal behavior. According to him, a behavior in violation of criminal law is criminal behavior, and criminal law is a body of specific rules of human conduct which are promulgated by a political authority. These rules apply uniformly to all the subjects and they are enforced by punishment which is administered by the state. This is only an enumeration of the characteristics of a crime which will not help us in recognizing a crime. Therefore, a definition of crime which is precise and which helps us in identifying a crime has not so far been provided by any writer. When a penal statute prescribes punishment for an act or omission, it is a crime. But regarding definition of the term crime, there is no satisfying definition which is accepted by all and applied in every situation. Even the Indian Penal Code, which codified the bulk of criminal law of India and is the general penal law of the country, does not define the term crime. Instead, Section 40 of the code simply states that an offence denotes a thing punishable by the code, and for the purpose of chapters and sections specified in subsection 2 of Section 40, the word offence includes a thing punishable under the code or under any special or local law. For the purpose of sections specified under subsection 3 of Section 40, the word offence denotes a thing punishable under the code or a thing punishable under any special law or local law with imprisonment for a term of 6 months or upwards with or without fine. This again is a statement and it cannot be considered as a definition of crime. Therefore, one can understand what constitutes a crime by following these three essential attributes. 1. An act forbidden by law or an omission commanded by law. 2. Such violation by commission or omission is prevented by sanction of punishment, that is, by inflicting punishment prescribed by law by the state. And 3. the wrongdoer is punished only after following a special procedure prescribed by law. That is, the guilt of the accused is determined after the accusation against him is investigated and he is tried by proceedings of a special kind according to the provisions of law. Thank you.